On behalf of Mr. Barrage Scott, who is approaching the podium, Mr. Scott, please state your name for the record.
Well, Dante Scott, sir.
How you doing, Brian?
All right, just glad to see my family in here. That's all.
Thank you, Judge.
Been here every time for you.
It's the People versus Barrage Scott, a case balancing mental health struggles against serious criminal charges. Today isn't just about guilt or innocence, it's about whether the court can risk trusting him again. The defense says he's medicated, supported by family, and ready to follow every rule. The prosecution says history proves otherwise. One side offers hope, the other warns of danger. And the judge, well, their decision today could change Scott's life completely, or keep him exactly where he is.
The report would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him.
The judge rules Scott competent, meaning he understands the charges and can help in his defense. This closes the door on any delay due to mental incapacity. But here's the twist. Being competent also means the court will hold him fully accountable for his choices. No more safety net.
July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that
Now listen to this. Scott's attorney lays out a heartfelt plea, painting a picture of a man stabilized on medication, with family ready to support him, and a willingness to accept court-imposed conditions. This is a classic defense strategy. Humanize the defendant, highlight rehabilitation over punishment, and show that release won't endanger the community. But here's the catch. The prosecutor's not buying it, and for good reason. Promises in court are easy. The question is, can Scott actually keep them once he's out?
Still has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor.
The prosecution's turn, and they're pulling no punches. They argue Scott's criminal history, and the facts of the current case prove he's dangerous. Notice how they focus not on what Scott says now, but on his past actions. In legal battles like this, history often outweighs promises, especially when the stakes involve public safety. This is where the defense's emotional appeals crash into the prosecution's cold, hard record.
Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks that he's asking for potential release.
Response.
And here's the decision. The judge denies bond reduction. The reasoning, a track record of broken trust. The judge recalls releasing Scott before, only for him to get arrested within a week. That's a huge red flag in bond hearings. In the judge's eyes, it's not about whether Scott is sincere now, it's about whether the court can gamble with public safety based on his word. Spoiler, they won't.
If you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and has
Nothing further, Judge.
Scott makes a direct, emotional appeal. This is raw, personal, and unfiltered. He talks about loss, addiction, and wanting structure in his life. These moments tug at the human side of justice, but here's the uncomfortable truth. Emotional honesty doesn't erase past failures to comply. Judges have to weigh compassion against risk, and in cases involving alleged violence, the scale tips toward caution almost every time.
Custody may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I'm
week
listening. I
later.
know, but he keeps saying the same thing.
Okay.
Saying the same thing that he said.
Okay.
He's not.
I believe Mr.
This
Scott wants to
exchange
address you
turns
directly.
tense. Scott pushes back, saying he's not being given a real chance to explain himself. But from the judge's point of view, multiple chances have already been given, and each ended in new trouble. This is a classic courtroom clash between a defendant's perception of fairness and the court's responsibility to enforce consequences. It's a sobering reminder, in legal terms, past behavior is the best predictor of future risk.
The right way, and the prosecutor is saying I was on I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. You know, I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something happens? No, listen.
Mr. Scott, no, you.
In the end, Scott stays behind bars. The defense leaned on family, mental health progress, and a promise to comply. The prosecution countered with history, and the judge chose caution. No bond reduction, no release. If this case grabbed you, like, comment, and
And now I
subscribe for
have
more
you
courtroom
involved
breakdowns.
in a crime that involves pointing a gun at another person. I'm done.
What do you mean?
Bond.
Listen, can you just let me
Motion for bond reduction denied. Bond will continue.
Thank you, Judge.
But
Go
you
ahead.
ain't let me speak,
Go
though.
ahead, Mr. Scott.
You ain't even let me speak.
Thank you, Judge.
Court calls the case, People versus John Terry.